Friends, we are starting now. Today is the 241st Friday group meeting. The topic is the outlines of law of limitation. The speaker is our beloved senior advocate, Mr. Dama Seshadri Naidu, the former judge of Kerala High Court and Bombay High Court. Sir also addressed on 2/12/22, that is Art of Legal Drafting, that is 164th Friday group meeting. The second time he addressed on 24th March 2023, Law and Literature, that is 175th Friday group meeting. Third time 15th March 2024, the Foreign Judgments and Indian Execution, that is the 208th Friday group meeting. Sir, your contribution for Friday group YouTube channel 48,600, sir. Now I request you initiate yours, sir. Please, amen. Thank you, sir.
This is enough, sir?
Enough.
Thank you very much, sir. I am grateful that I've been given an opportunity, perhaps one too many a time. And to begin with, I wish all of you a very happy, healthy, and prosperous new year. As usual, I am grateful to Sheshagiri sir for providing me an opportunity to be amongst you. And that made me, when he called me up and said that let's begin the year with your lecture, and I thought that I'd better take some offbeat subject. That's how I chose the outlines of law of limitation. This is the subject everybody feels, everybody knows. And at the end of the day, we get caught sometimes. That's why I thought that, well, let's take that one as a subject. Now, let me tell about my association with Friday Group. I came over here as a former judicial officer, as Sheshagiri sir has just said. I thought that could be my identity. It was, but to a limited extent. The maximum identity I got was through Friday Group.
Thank you very much, sir.
Last month, I was arguing a case in Orissa High Court. During the lunch time, I had to meet a friend of mine, a judge over there in his chambers. I went over there and I met him. Meanwhile, another learned judge, Honorable High Court judge, dropped in and he saw me. He didn't know until then. He saw me and said, "You are Friday Group." Imagine a High Court judge watching Friday Group. Then I'll tell the second one. It's a sort of a great escape for me. Earlier, as a judicial officer, usually you were not required to show the identity card in airports. So sometimes the old habits carry and you don't carry that one. One day in Delhi airport, I did not have my other things. But I had my bar association or our bar association card, Supreme Court, etc. I showed it for my identity. He said, "No, it's not government issued, we will not accept it." I was in desperation. I've told him I'm a lawyer. Still he said, "No, you have to show me identity." I said, "This is the one." And I've taken my phone, I've showed him YouTube and the Friday lecture. He said, "Please go." And the last one that happened on January 1st, a couple of days ago, I went over to a medical shop along with my wife. I told my colleagues also. And I purchased something. The salesperson there, a lady, asked me, "Sir, I have seen you somewhere." I said, "Are you a lawyer?" "No, sir, I'm not a lawyer. But there are lawyers in my family too." Then I said, "I don't know where you have seen." Then she took her phone and she showed me Friday Group. "This is where I saw you, sir." I don't know why she referred to that one, because she's not a lawyer. But anyway, that's how I owe a great deal
You come in the public domain.
Yes, sir. That's how I owe a great deal to Friday Group. Thank you very much once again. Let me come to the brass tacks. You know, this mouthful of an expression you must have read anywhere, fiat justitia ruat coelum. Let the heavens fall, justice must be done. Then the next question as a sequel is, what is justice? I don't know how many of young lawyers over here or across the tube watching have read Francis Bacon, one of the early fathers of modern English prose, Francis Bacon. The very popular one is his anthology of essays, Francis Bacon's essays. In that one, the very first essay was of truth. And the very first sentence in that essay was, Pontius Pilate. Have you heard this name?
Yes, from Julius Caesar.
Yes, you're right. Pontius Pilate
Of reading and
was the Roman judge or a revenue officer or the governor who tried Jesus Christ. He felt he was innocent, but there the Romans were praying for his blood. So he succumbed to public opinion. So he rather punished Jesus, and that's how the history was made. So in that one, Francis Bacon says, what is truth? But he does not wait for an answer, because he knew the futility of waiting for an answer, because truth has many shades. So is the case with justice. What is justice for you, right, may not be justice for somebody else. What is food for someone is poison for someone else. So what we would be confining ourselves to is not the nebulous or elusive concept of justice, but that of law. And when you take a subject like law of limitation, it has no principle of equity in it. It works rather harsh sometimes. Let me quote a couple of examples whether we are doing justice under those circumstances. You know, a judgment I'm referring to is from Illinois Supreme Court. What happened? One day, a robber who wanted to rob the bank went out to the bank with a gun and a mask, cinematically. He held his gun to the customer standing by there, then demanded the teller or the cashier, you pay up the money, hand it over to me, or else I'll shoot him. There the cashier was petrified, overcome by fear, could do nothing and just stood still. Then this man lost his cool, rather patience, and shot the customer. Then the elders of, as we put it in the legal terminology, the dependents of that person sued the bank for compensation. Because it was a getaway, he just ran away. Maybe the police must have been in hot chase of him, they could have caught hold of him, or we don't know. But the fact remained, he died in the bank premises. He was a customer of the bank. When he went over there, the bank's inaction perhaps could have caused. If you think of in logical terms, please remember, any amount of money lying in the bank is always protected because it's been insured. So even if they had paid, there wouldn't have been any real term loss for the bank. But still, he did not. The cashier was petrified, as I said, stunned into inaction, and this had happened. So the LRs sued the bank for compensation, or the tort, whatever you call it. Then The matter reached the Illinois Supreme Court. You were on the bench of the Supreme Court. What could be your ruling? Isn't that family entitled to compensation for the lapse on the part of the bank? Remember, in pecuniary terms, in money terms, there was no loss otherwise, even if it had been paid. Under these circumstances, could the bank, as you may think, have any valid defense? Anybody could contribute, or else I'll give my answer, because I'm wiser with experience because I've read that one. Yes, please.
That man has entered the
Yes, sir, please.
cage here with a gun. It should not have been allowed. That's one way the bank would have.
Yes,
Second one, petrified or what, he should have said, I'll pay you when I recover.
You're right, sir.
So the shooting should not have taken. So
Yes.
he is entitled to
Thank you
my
very
logic.
much. Thank you very much, sir. Sir, please remember this binary thinking we all suffer from, always thinking right or wrong, yes or no. But in law, we have to shed this binary thinking. There can be many answers to even a single question. And this concept of right answer is a mythical one. So as many times you can see the judgments in the facts and circumstances.
Yes.
That's why. But in that case, what has happened, I'll give another analogy for that one to justify the bank stance. You know pretty well, I've cited earlier too, that a plane was hijacked. Say about 450 people on board. Then the hijackers make a demand to the government. It happens, or it happened, that you free one of our leaders who's been in your custody so that we can let go all 450 passengers. Think commonsensically. One person who is to be released, and that person can be caught again, there is a chance, and 450 people who are sure to die otherwise. It's one life pitted against 450 lives. What do we say? We say he should be released so that 450 we could gain back. Again we can go in hot pursuit and get hold of him, perhaps. But you know, maybe when we were all young, many a times we read in newspapers, in that country plane hijacked, in that country, in this country plane hijacked. In the last 30 years, have you heard any hijack? No. The reason is this, sir. Internationally, all countries have come together and taken a decision not to yield to the demand, come what may. The moment the terrorists have realized it doesn't pay, they have stopped. Here also, Illinois Supreme Court has said, if compensation is paid, it gives another weapon to lawbreakers to hold somebody for ransom and get the money. So, judicially, this dichotomy is called ex post thinking and ex ante thinking. Ex post thinking is some harm has happened, you have to redeem that one or compensate. This is ex post. Ex ante is whatever harm has happened, if I redeem it, what's its consequence? So that's why I'll tell you another example. This is my piece of land, the next is my neighbor's. I construct a building on my piece of land, but rather innocently, bona fide, I trespassed upon a part of my neighbor's land without knowing in that construction. I completed my construction, then I realized, though it was a small extent, if I had to come out of that one, I had to tear down my whole building. It would cost me say 10 crores. Whereas his whole plot is worth 1 crore rupees. I could pay him 2 crore rupees for, see, 5 cents of that one or 1 cent of that one, and he could still have his plot retained. Then he goes to the court saying that I should remove the offending part of the building on his land. You being the judge, what could be the answer? The answer perhaps is, save the resources, save the building, let him twice over. But if that's allowed, it gives a license to the lawbreakers. Everybody pretends he was innocent. He will have a building built on the neighbor's land too, and he always thinks I can pay and get lost. This is ex ante. Now please remember, we have seen one judgment from Supreme Court a few years ago, where 2 high-rise buildings in Kerala were razed to the ground. There the government ex post facto regularized this construction as well. Still court said you can't have a license to violate law and redeem it later. This is ex ante thinking. Right? And remember another one, that Vyapam scam in Madhya Pradesh, when medical students were admitted without, or rather malpractices were accused of, and then they had that one. And eventually they passed out pending the litigation. Then this honorable court, there was a split verdict. One honorable judge said, anyway they have passed a medical examination, they have become doctors, they have been serving. It's a national waste to strip them of medical degrees, let them serve, but with an undertaking that for 5 years or 10 years they should be serving in the rural areas. This is ex post. So past something has happened, let's preserve it and see the compensation, whichever terms. But split verdict, then again it was 2-3 judges or whatever, they have said no. Then in every case, by the time this admissions happen, people cut corners, they get admissions, they get their degrees. By the time the matter reaches the apex court or wherever it's finality, then it gives that one. That's why again they have said, and with the last example, I'll just come to the concept of law of limitation. You know what happened? It's again a reported judgment. Once, a police officer was on patrol duty. He saw, that's his version, he saw a man with a knife in his hand chasing another man, perhaps with a view to killing him. Then he shot him dead, perhaps to prevent that calamity of this man killing another man. And then it was a case when others reached the place of offense, contrary to this police officer's assertion, the man who was shot dead on an allegation that he was chasing another man with a knife, there was no knife to be found. Right? Then this police officer, when the family of the deceased was suing this police officer and the department as a whole perhaps, this police officer visited a psychiatrist, a doctor, with a problem allegedly of hallucination, that of seeing things which are not there and vice versa perhaps. Then during the trial, the LRs of that deceased family filed an application for the production of evidence, the medical case record of that man from that psychiatrist. Please tell me, should it be produced or not to be produced? Any idea?
Normally it would be privileged.
Precisely, sir. It's a privileged communication. I'll give an exception carved out by our Supreme Court. Before that one, let me tell you, perfect answer. In a sense, that's what's been held by that court. It's a privileged communication. Why it has become privileged is the next question. You know, wife and husband, privileged communication. Then attorney and the client, privileged communication. Doctor and patient, privileged communication. Why? The reason is this. You take the example of mediation. When parties are referred to mediation by the court, and the mediator, much less either of the parties, is not expected to tell the court what has transpired in the mediation. He can send a simple sentence, mediation failed. If mediation succeeds, he can give all reasons possible. Why? Why should not the reasons be given? You know, I tell you, we are all human beings. We'll have our prejudices. A classic case, when I was deciding a case in Bombay with regard to eviction. An industrial plot was given on rent to another person, and the time was over. He did not vacate. Then the owner had to vacate him through due process of law. That takes ages. It was going on. It reached High Court. In the High Court, the judge referred that to mediation, and mediation failed. They both came, they reported to me, mediation failed. The advocate for the landlord, maybe cleverly or with a sinister design, has said, my lords, he is paying 5,000 rupees rent, he demands 10 crores for eviction. The damage was done because I got prejudiced. This is one problem with privileged communication getting leaked out. The second one is, let's assume a person comes to me, a client of mine, and confesses everything to me. And my moral antenna rises high and goes to the court and said, look, he has committed the murder because he has done that one. Then who will come to the advocate and who will divulge the whole thing and find a proper defense? And when you go to a doctor, we have the fear at the back of your mind, one day the records will come out and you'd be exposed, you'd be incriminated. Would anybody come forward to do that one? So that is the sole purpose of protecting these. Yes, sir. We have got a question. Please ask.
Not a question.
Question last, sir.
Okay.
Right, sir? Now, that's why it is not law needs to be an ideal to be met, but it is a pragmatism imbued with all practical wisdom. That's what law of limitation is. So, even heavens fall, let's stick to law, not to justice. If justice comes within the purview of law, it's accepted. Take the example of excise laws. Today I drink, make merry, the next day there is prohibition, it becomes illegal. Justice must be common and uniform, always eternal. It will not be fluctuating, but law does, because law is essentially a matter of public interest. Now that's why what's been said again, every litigation must come to an end in the public interest. This is one principle. Of course, you have got Latin maxims for that one. Let me put it plainly. Every litigation must come to an end in the public interest. And the other one is, law must assist the, vigilant, not the indolent. One is who is active, one who asserts himself on time, should get the relief, not somebody who sleeps over his rights. So one is a principle of public policy, as I said, everything must come to an end within a reasonable, foreseeable time. And the other one is that of equity, that law you may have in your favor, but you should make use of it at an appropriate time. You can't drag for an eternity. That's why the equity principle and the public interest are the two, heartbeats of the law of limitation. Now, there is one particular concept. We always say that law of limitation bars the right to remedy, but not the right itself. This is one thing we say. And sometimes you lose your right as well. So one is limitation, the other one is prescription. So let me think of what is the difference between limitation and prescription. I've just set out a couple of differences here. When it comes to limitation, it bars enforcement. When it comes to prescription, it not only bars enforcement, but also extinguishes your right. This is one difference. Then, for that precise purpose, law of limitation is always a shorter period, whereas Law of prescription is always longer period, usually in years. And the next one is, once limitation begins, it never gets interrupted. Whereas prescriptive rights can be interrupted and the renewal begins. Your right stands saved. This is another difference. Then, one can be interrupted, the other one cannot be interrupted. And finally, let me tell you, when it comes to limitation, the right continues, the remedy lost. But prescription, not only the right, but also the remedy, both have been lost. You take the example of section 27 of Limitation Act. It speaks about prescriptive rights. And there is another cardinal difference, that is, limitation belongs to adjectival law or procedural law, whereas prescription belongs to substantive law. Why this distinction? Procedural law changes from forum to forum, whereas substantive law does not. In private international law, it assumes more importance. Procedural law is always lex fori. The forum where, for example, two parties agree to arbitrate. They say the law of India should apply, but the seat of arbitration is in London. A court in London decides that one, but applying Indian law. Then the catch is, Indian substantive law it should apply, not the procedural law. Right? The procedural, lex loci when it comes to substantive law, lex fori when it comes to procedural law. These are the differences when it comes to limitation and prescription. Of course, in layman terms, we use them rather interchangeably, both ways. This is one thing which is quite substantive, you may keep in mind when it comes to the rights. Now let me come to certain important provisions. Those provisions, for example, just a while ago a friend was telling about section 14. Let me begin at the beginning perhaps. When it comes to section 3 of the Limitation Act, what does it say? Even when limitation is not taken as a plea, still court is duty bound to decide the period of limitation. Now I'll put a question. What should happen if court is unmindful of the limitation and neither party has brought that to the court's notice and it decides? What happens to the decree passed by the court? Is it a nullity or not? Could anybody answer?
Sir, it will be validated.
It is validated. Good answer. Thank you very much. Provided there is a provision for validation. Right. Thank you. Then, section 4, it talks about when courts are closed, what should you do? The holiday saves the limitation, but the immediate next reopening day you should have. And the darling of all lawyers, especially the lazy lawyers like me, is section 5. The delay condonation. Right? We swear by it, we live by it. I need not expatiate on that one. But here, I would like to have an important aspect. I was telling about public interest. That law is a facet of public interest. The very subservient purpose is that one, accepted. Then many times you have seen one of the classic judgments on the topic being living media versus Postmaster General, where it's been said government can't sit on a different pedestal, etc. Accepted. More so, court has been exasperated with numerous delay petitions filed by governmental agencies. That's why they have come down very heavily with the justification. But always remember, an individual will take the blame, will take the consequences once he is not active in pursuing his litigation. When it comes to government, it's a faceless agency. If the problem is of many, it's not the concern of any, is the saying. When that is the case, if courts don't apply a special principle, public interest may suffer. At one branch of thought you could explore, otherwise they go scot-free because an official, he just delays, then somebody gets the advantage, he merely retires. That's why these days courts have adopted a method of condoning sometimes the delay, be it a large amount of delay, but still asking the department to penalize the party who is responsible or the officer who is responsible. Perhaps it's an equitable approach. Instead of saying that government doesn't enjoy any privilege, but perhaps it may have a better way. Then section 6, 7 and 8. Right? Section 6, 7 and 8. What do they talk about? They talk about saving of limitation vis-a-vis the minors, vis-a-vis the lunatics, vis-a-vis the idiots. Not a negative term as such, it is a word of art in terms of Limitation Act. All these people who suffer from limitation, and they could have the limitation extended until that ceases, thereafterwards as if it began on that day, it would be 3 years. Then 7 has an interesting one. When there are more than one person to sue, and one of them suffers from a limitation, a disability rather, then what should happen? Whether it's divisible, whether somebody else can ratify that one, he can carry on his behalf, then limitation is not saved. Otherwise, it is saved. 8 is an exception to 6 and 7, we need not focus on that one. Now let me come to section 9. It talks about continuous running of time. As I said at the beginning, once limitation starts, it doesn't stop. Whereas prescription can be stopped. This is another aspect we may have to focus on. Then let me come to section 12. Section 12 talks about you have an order to be challenged and you have got, say, time for applying for certified copies and getting them and then filing all the ministerial acts. They would be saved. For that purpose, 12 has come into existence. And now let me come to the topic, sir, you have raised. That's section 13 and section 14. What is the subtle difference, subject to further exploration, I may say, 13 and 14? If you pursue a remedy before a court of law which has no jurisdiction, 13 is the answer. If you have pursued a litigation before a wrong forum but not entirely denuded of jurisdiction or subject matter jurisdiction or inherent lack of jurisdiction apart, then it may not be an efficacious remedy for you. For example, instead of invoking a statutory remedy, you invoke public law remedy under Article 226. Then at the end of the day, you may spend 5 years in pursuing that litigation. And the court feels that you have an alternative efficacious remedy. We'll relegate to that forum and go. By then, limitation could have been over. In that context, what will you do? That's where 14 comes to your rescue. I've read in some of the commentaries saying that remedy or relief under 13 is discretionary, but not under 14, it's mandatory. But subject to further exploration by young minds, I have my reservations about that concept. I believe both are discretionary. And most of the times when we request before the Honorable Supreme Court that my Lords may kindly observe that I can invoke section 14. And their Lordships always will say that who prevents you from invoking that? If you invoke, it's entirely for the court to take a call on it. So that's why this subtle distinction between 13 and 14 may have to be appreciated. Then let me come to section 17 as well. And that talks about the fraud. For example, there is an order passed by a competent court. You need to challenge, and your opponent with a stratagem, a clever strategy, prevents you from knowing it. Or else he may say, for example, no, let's compromise. You need not go to court today, I'm going to take time. And let's sit across with a glass of wine and then settle the matter. He beguiles you into a sort of a false sense of security. And then you were absent, the court decrees in his payout perhaps in absentia, and you did not know, he would just take you along saying that we'll compromise, down the line 6 months, 1 year perhaps you come to know that it was over. Once you have been prevented by stratagem, by fraud, whatever, the limitation starts to run from the date you have discovered it. And now, another important provision is Section 18. Let me put in plain terms. You owe money to someone, and you know pretty well that the limitation is 3 years. To save the limitation under 18, Section 18, what is that you have to do as a creditor? The debtor should acknowledge, right? The debtor should acknowledge that he'll pay the amount, and that acknowledge must be in writing, and it should be given when the right is subsisting. Once it extinguishes, then 18 will not come to your rescue. Then which provision come to our rescue once it's extinguished? Yes, I thought you would fall into the pitfall, you almost fell into it. Rather than 19, it is Section 25 of Indian Contract Act. 19 speaks about part payment. Once you pay in part, you are saved. But when it comes to Section 25 Indian Contract Act, even a debt barred by limitation can be acknowledged and renewed in writing. Then an interesting question you can examine. So far Supreme Court has not ruled on that, I believe, subject to correction. That is, suppose I owe money to you and I have not paid that to you in the next 3 years. It's been barred, but I was not aware of that one. And you come and demand, say 3.5 years later. I was under a mistaken impression that it was still within 3 years. My opinion never matters, it's only the law. It's a matter of arithmetic or chronology. Then I give a check to you. Does it qualify to be an acknowledgement in terms of Section 25 Indian Contract Act? Half a dozen judgments from High Court say, yes, it does qualify. Half a dozen judgments say it does not. One judgment from Kerala High Court took a view that it does not save the limitation. And that was taken to Supreme Court. Supreme Court refused to interfere. It does not mean that it has given judicial imprimatur. It simply refused to interfere in terms of its power under Article 136. That's why there is no final word. But authors like Bashyam and Adiga, and another wonderful book on dishonor of checks, Rajesh Gupta, they both have felt that once a check was issued vis-a-vis a barred debt, barred by time, it amounts to revival in terms of Section 25. Now that's where we are. Now Section 20. It's a very clever provision. Section 20 says, if you pay the debtor, as a creditor, I get a fresh lease of life to sue you in the next 3 years from that day. But you have not paid, your agent pays. Still it gets extended. Then what happens? I set up, you refuse to pay, and I have no time to sue you, perhaps for whatever limitation I suffer from. And then I set up a person, I treat him as your agent, and he pays me. Then I sue you saying that your agent paid. That's why Section 20 uses the expression duly appointed agent. Under Transfer of Property Act, you have got even ostensible agents. Right? Ostensible agency comes where? Suppose, I'll give you an example. A piece of land is there, house plot for that matter. I am the owner of the property. I am standing over there. Right? My son brings somebody else and he says that this is mine, why don't you have it? He trusts him. He enters into a contract and he gets it executed through a registered sale deed. Tomorrow I say that I am the title holder. If he can establish before the court of law that it happened with my tacit consent, it amounts to implied agency. See, that's why, please remember, especially science students get a bit disappointed with law. But your critical thinking may help you, I accept. Because law is like cricket, glorious uncertainties. There's no mathematical accuracy. If there is mathematical accuracy, law must have been frozen long back. How could you get every day, as newspapers put, landmark judgment today, landmark judgment tomorrow? That's why I used to tell young lawyers, think absurdly, think out of the box. Don't go by the precedent. And you know the concept of continuum when it comes to precedents. I'll show you a classic example here, because one of the core topics I would like to address is that of adverse possession. And you take the judgments of 1950s from the Supreme Court, most of them constitutional benches. What they have said? What they have said? They have taken that Roman adage or maxim, nec vi, nec clam, and nec precario. What's meant by that one? Nec vi. Should I read that one?
Please.
One is openly, nec clam, not concealed, nec precario, in a hostile manner. Beg your pardon?
No.
Right. So, the courts have said, if you hold on to a piece of property as if it belonged to you, please remember this subjunctive, as if it belonged to you, and you have not concealed the fact that you have been in possession and enjoying the property, and it's not secretive, stealthy when it comes to your approach of asserting your right over the property, then despite such public act of hostility on your part vis-a-vis the supposed true owner, you need not even acknowledge that there is a true owner. You say that I am the owner. Right? But still, if the true owner does not act within 12 years in terms of Article 65, you have perfected your right in terms of Article 65 read with Section 27, prescriptive right. It's not only the barring of remedy, extinguishment of right. Now please, let's take an example. You know, any of you can lay your hands on 2001. I tried to get that one online, I could not get that one. 2001 AR May Part Journal section. There is an article on adverse possession written by a former judicial officer, a district judge. I have never read a better article than that one on that topic. The same way, if you want to read, instead of 1000-page commentary on law of precedent, please read 5-page article by Goodhart. It's available on another website. You simply type the Doctrine of Precedent by Goodhart. Even a 1000-page book would not answer all the questions that answered. There are certain classics you can't. And earlier also I've told you how to, as an AOR, dictate effortlessly. I said, read the article called, what do you call? MACJ, Madman, Architect, Carpenter and Judge by Betty Sue Flower. Right? Now let me come back to this one. Now, in a Privy Council judgment, that article refers to, you know what happened? One person owns the property, supposedly, and he gives that property on lease to his neighbor. Right? The neighbor continues to enjoy the property, say 10 years, 15, 20 years, but as a lessee. Right? As a lessee. Then down the line, this lessee, again supposed lessee or putative lessee, comes to know the property actually belonged to his father. And the neighbor, in godforsaken years, long back, trespassed and occupied, and everybody forgot. So the title lay with this man, rather his father. So then when the other man asks to return that one from this putative lessee, he asserts and shows, look, registered document in my father's name. And Privy Council said nothing doing. Because the other person enjoyed as if we were the owner. He never concealed that fact. Right, you were aware that he had been in possession. Had you been the owner, you would have probed and you would have got it. This is one judgment. that throws light on that aspect. And let me have 1951, one judgment, that is Collector of Bombay versus Municipal Corporation of Bombay. It's a 5-judge bench decision. In that one, what has happened? The British government passed a resolution to grant a piece of land, a large chunk of land, to this municipal corporation for a market fair, whatever. You can read the judgment. I'll tell you which is that judgment. I've just taken that also. This is 1951. Sorry, I've taken AR also somewhere. AR 1951 SC 469. AR 1951 SC 469. In this one, what has happened? This government, you know the year 1865, grants a piece of land, large chunk of land, for the market fair of this municipal corporation. And there was no resolution, a proposal was there, possession handed over, it's never been sanctified, legally acceptable manner. And in fact, the authority who proposed and who transferred, who passed the resolution, had no power to do that one. So in a sense, it was a sort of a void transaction or a void agreement under which it's been passed on to them. 70 years municipal corporation continued. Then the government demanded you give it back. Municipal corporation, being a different entity on its own, asserted, saying that no, I've got my right perfected because I've got property under a void transaction. So from day one my possession has become illegal, and you have never questioned that one in the limited prescriptive period. That's why it's been barred. And 5-judge bench with a verdict of 4:1 has held that it is true. Right. Now, you know what happened? Times change. Times change. You have seen 1970s and early 80s, people used to say Supreme Court has been swayed by socialistic tendencies. Right or wrong, this is intellectual freedom in a lecture we all enjoy. We are not commenting on anybody. We are only saying the public perception. Then you have seen judgments, what you call social consciousness as they put it, or sociological leanings at that time. Then economy opened in perhaps late 90s or mid 90s, etc., thanks to all people concerned. And then one of them recently passed away. So then what happened? Law has not changed. Now you see the attitude. The courts have attuned themselves to the changing times. And the same way, when our society was essentially an agrarian society, so was the case with British society. This adverse position was serving a social purpose, that of putting a finality, because I occupy a piece of land, say agricultural land of 5 acres. I have been cultivating for say 30 years or 20 years, and then I modulate my lifestyle. My entire family depends on it. And then down the line, 2 decades later, the true owner comes and knocks the doors of the court. If I lose the life. This is the purpose behind that one. And one of the judgments, Supreme Court has said, it's a jungle justice, where the true owner loses the right. Why? Because with the urbanization, with access to lands made easy, access to information made easy, people should not be allowed to take advantage of their own wrong is the moral concept that's been introduced into adverse position. I have said this binary thinking of right or wrong is not the question here. As the times change, legislation doesn't change every day, but the judges' views to some extent to sail along. That's why Benjamin Cardozo says, times will not just pass by the judges who are sitting idle, they do affect them. Right? That's why earlier you just turn the legal journals, law journals rather, of 50s, 60s, 70s. If there are 10 judgments on say civil law, for example adverse position, the success rate of person asserting adverse position could be 70%. Now it is 10% or less than 10%. Now I'll tell you the 2024 judgment, the latest judgment. What is the judgment? Radhe Shyam Lal's case. It was delivered on 18th March 2024. What's been said? The person who is asserting the title in himself as a matter of adverse position must also be aware who the true owner is. Here, I just began the whole discussion with one word called continuum. You know what's meant by continuum? 1951, you have seen how the law began. It has only said your possession must be open, peaceful, and hostile. Unknown to all. Hostile in the sense known to all. No suppression, no secrecy. Right, it's not by violence you wrenched it from somebody's hands. If these things have met, that's it. You may bona fide believe you are the owner. You need not acknowledge the title of somebody else. That was the law, how it began. The classic law if you read Mantha Ramurthy's. But down the line, the courts felt that it's not doing justice. It's not serving the purpose. It may be giving some sort of a judicial imprimatur to a lawbreaker. Then they have just diluted. So, a deviation, when you draw a straight line, it slowly deviates by the end of 1 mile. It's almost a circle. This is what judicial continuum is. That's why, in recent judgment, Supreme Court has said, law of limitation cannot be trifled with. Our moral notions will not trump it. And there's nothing like equity in law of limitation. Statute prescribes, it may work out harsh. To sign off my discussion on this topic and invite certain questions, let me tell you, when it comes to the repeated assertion on my part or explanation that it's not a matter of equity, let me tell you, there are 3 phases when it comes to modulating our conduct vis-a-vis the state. One is the precedent. When William the Conqueror or William the Bastard from Norman French invaded England in 1100 AD, he thought that he should bring the whole of warring principalities of England or Great Britain, now it could be called, in one umbrella and apply the law uniformly. That's how, when it's been commonly applied across all counties, etc., it's become common law. So these judges, they're called circuit judges. They went about in circuits. Instead of deciding cases afresh, they started saying, oh, this case, similar case we heard in Kent. So Middlesex, same rule should be applied. So they've stopped applying. It became a tyranny of precedent. Then all the disgruntled people, they have complained to the king. King called his chancellor and said that please look into it. The petitions got piled up. So Chancery Court has come into existence to transcend the principal limitations of precedent and then apply law for each case in an equitable manner. And when both have been combined, statutes have come. So first precedent, then equity, then statute. Once statute occupies a field, neither precedent nor equity comes into play. This is how the law operates. This is how law of limitation operates. It's imbued with twin principle of public policy of having everything to come an end, and equitable principle that only the the active person should have the remedy of law, not the indolent, not the lazy. That's how these things have come. And also the last one I should like to say is with regard to law of specific performance. When it comes to the limitation, you think of, we all know the common law principle again. When it comes to immovable property, time is not the essence of the contract unless it's made expressly so in the contract. Accepted. Earlier again, it's agrarian. The appreciation is very minimal. So always it's been said that time is not the essence of the contract. Now complete urbanization. Every day they get multiplied. So suppose somebody says that the contract should be performed by so and so date. He has not performed. And law provides that 3 years is the time from the date prescribed there, unless limitation is rather time is the essence of the contract. Then the question is, whatever the time prescribed in the contract, should it be adhered to, or the party can wait up to the last date and do that after 3 years, rather within 3 years. It's a raging debate. You take any number of judgments on both sides. Once law prescribes, if you talk strictly, then equity doesn't apply. So from the date of rejection, it is 3 years, which is the provision that is article. No, is it 54? Just kindly, you can correct me on that one when it comes to specific performance. Which is the article that says from the date of Article 54 only. Article 54, right? 3 years from the date of refusal or the date fixed for performance. Then what should happen to the solemn undertaking of the parties in the contract? That's what recently a 3-judge bench of the Supreme Court has said. Can we ignore that one? It's a debatable question. Statute provides you 3 years, but parties themselves have provided within that sphere a particular date. Which one should prevail? And the debate rages. And there may not be any final word on it, but it depends on facts and circumstances, sometimes based on the appreciation and all other considerations. Now, having said that one, perhaps we may have a little more time here to invite a couple of questions, please.
I have one. 1 second. When did you get a question?
Yes, sir.
Please continue.
No, I said that I can invite the questions.
Okay, please.
Because we thought 3:30.
No, we'll finish and then we'll ask for
Yes,
question
please.
answers.
Yes.
Thank you very much, sir. Thank you very much. You have taken a lot of valuable time on this limitation from Francil Bacon to Benjamin Cardozo, section 3, 5, section 14, 13 and section 17, 18, section 25 Indian Contract Act, whatnot. Let us give a standing ovation to start. Ventilating that.
Thank you, sir.
Rahul,
So kind.
Mr. Rahul Sharma will give a vote of thanks quickly, please.
I feel honored and privileged to propose a vote of thanks for the first lecture of 2025 delivered by Senior Advocate Dama Seshadri Naidu sir. Sir, we are privileged that you have taken out time from your busy schedule and given us so much information, knowledge out of your wisdom and experience, which we don't get through textbook or through any curriculum. So I would quickly recapitulate the lecture. We talked about the English philosopher Francis Bacon and his essays like Of Truth and Analogies. We talked about ex post facto, the principle ex ante, and the concept of the law of limitation, equity principle, and it was very comprehensive. You talked about sections like 3, 4, 5, 6, 27, section 14, 5, and 6, 17, 18, and the law of limitations. And you talked about the adverse possession and the limitation laws related to adverse possession. And concluded the lecture with the principle laid out by William the Conqueror of Normandy, France, when he ruled England in 1100. And so the basic foundation he laid for common laws. Thank you so much, sir. On behalf of the Friday group, we thank you. And Seshu sir, thank you so much for giving me this opportunity to propose the vote of thanks.
Thank you, Rahul Sharma. Now we'll go for question answers. You can cover.
Can I ask?
Yes, sir, please.
So in Article 226 writs, the concept of laches deals with
Laches.
Laches.
Yes.
And the second is res judicata would also deal with to put an end to litigation.
Yes, sir.
And also lastly, Article 141 of the Constitution would deal with the law of precedence.
Yes, sir.
And I just have to share one thing which is like burning in my heart. One senior advocate who had given an opinion to a bank about how to prevent Nirav Modi from going away. When public made his opinion, which was privileged, put it in the newspaper and said the government did not act upon it. My opinion on how to stop him from leaving without paying back. So I met him and asked him, wasn't it privileged? Why did you make your public opinion public, which was given to the State Bank of India? He said, for public interest, I don't care about privilege. For public interest.
It's a personal view, sir. We can't have a uniform view on that aspect.
Yeah, anyone questions or any further question? We have to attend, the CBS farewell function also. Sir was in the same bench when C.T. Ravikumar was in Kerala. So that is also another important this thing. Kindly join, we'll take your autograph, sir, then your
Yes.
message also. Then we'll join for a cup of tea.